Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about excessive noise on land developments. Cases that should have gone to the Supreme Court of Canada, but didn't. Sean Milne owned some property, which was ultimately expropriated by the government for the purposes of putting a railway in. During the railway construction, and then after the railway was put into place, Mr. Milne complained that he wasn't fairly compensated for the loss of his property because of the excessive noise from the railway that interfered with both his use and enjoyment of his remaining property, as well as limited the property value. The court disagreed, did not award Mr. Milne any damages, and found that he was fairly compensated. He appealed, lost, sought leave to the Supreme Court of Canada, and they denied leave. And this case does raise very important issues. As we see problems in this country right now of housing shortages and a housing crisis, governments are taking increasingly aggressive measures to try and address shortfalls in housing. One of these aggressive measures may ultimately end up being the expropriation of some property to build accessible, affordable housing for individuals. I don't think that we're too far off from governments taking those steps. But as they do that, property values may decrease, not only by moving in lower cost housing, which devalues the property in communities, but also by increasing the amount of noise and noise pollution that exists in an otherwise quiet community. This too can have an effect on property values, and governments need to fairly compensate individuals who've made choices to purchase quiet properties if that quiet enjoyment is going to be interfered with. As we see governments taking increasing measures to increase development and the construction of residential real estate across the country, having very clear guidelines from the Supreme Court of Canada as to in what circumstances people are going to be compensated for the noise that is caused by construction developments, as well as increased noise as a result of construction developments, particularly where those are led by government efforts, is going to be an important issue. The Supreme Court of Canada could have got ahead of what is a likely political outcome in this country to give guidance to everybody so that people know what their rights are and so government knows what its obligations are moving forward. And the unfortunate result of this is there's likely going to be more litigation about decreased land values in expropriation situations where construction is then done. And because of that, we're likely going to see more time taken in court to try and determine these matters on individual bases without clear, compelling guidelines from the Supreme Court of Canada that recognize the current realities of the housing crisis in British Columbia or in Canada, and that recognize the current realities of how property value is assessed. Hopefully the Supreme Court of Canada gets another opportunity to decide a case on these important issues before we see governments engaging in more aggressive measures that may involve expropriation of property to build housing. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.